I'd like to thank everybody for coming to the library this evening. We're going to conduct our debate for Circuit Court of Hancock County. We'll have three gentlemen here to answer questions. Each of you should have been presented with a postcard. If you have a question, please jot it down on that piece of paper, hold your hand up, and one of the debate committee members will come and get that question. We will do everything in our powers to get those questions asked, depending on the time. We're going to try to go for 1 hour this evening. The format is going to be each candidate will get the opportunity to answer the same question. First question will go to Mr. Sirk. Next two gentlemen will get to answer the same question. The next fresh question will go right on down the line. Okay? Do you gentlemen have any questions?
No, good.
Okay. We have 4 prepared questions that we're going to use. There will be no rebuttal time. We're going to use as many questions from the audience as time will allow. Each response, you will have 2 minutes. We have a timekeeper sitting here in front of us that will give you a 1-minute mark and a 10-second mark and a let's stop talking mark. Okay? At the end, we will have 2 minutes to give a closing statement that will be afforded to each of you. Are we ready? Mr. Sirk, what are your top 3 priorities for your time in office if elected?
Well, my top 3 priorities, number 1 is to address the drug epidemic in Hancock County. And the best way that we can address that is it's a supply and demand problem. The best way that we can address that is to end the demand through the rehabilitation that we have already in place by drug court. We have an 80% success rate in the graduates of drug court right now. And continuing with that, working with mental health professionals, because drug addiction ties into mental health, rehabilitation specialists, addiction specialists, probation officers, we have a good chance of success. We end the supply by, as I've already been in my experience already as your circuit court judge being appointed by Governor Holcomb, I have already been tough on crime and tough on dealers, but fair. And I take each case fairly and each case individually, but dealers are a different actor. Additionally, then I continue to be compassionate with families. In the family law docket, that's one of the most important things, and I'm always there to listen, to speak to everyone who has a chance to speak and be very compassionate in regard to that. And finally, I would say another issue that I've already started to address, meeting with the Mount Vernon School Safety Program through Dr. Shane Robbins, the superintendent there, is school safety and encouraging already the great plans we have in regard to that, uniting law enforcement, probation officers, juvenile probation officers, and the court into ensuring our schools are as safe as possible. Thank you.
Thank you. Mr. Woolrich, what are your top 3 priorities for your time in office if you're elected?
It's going to be very similar to probably what you read in the newspaper. My top 3 priorities first starts with, I have a campaign slogan I've had for a couple of years, Listen, Think, Act. To me, one of the most important facets of a judge is to listen to all litigants, treat each case like it's the most important of the day, whether it be a small case or a large, very financial high case. It doesn't make a difference. You've got to make sure you listen at all times and make the litigants think that, or at least feel that you're listening to them. The second issue that I said that is more something that the lawyers understand, and it is to improve the efficiency of the court. Many times, if you've ever been a litigant or an attorney, you know that when you get into the courtroom, many times you have to sit there for quite a while, sometimes hours. And I'd like to cut that down so that we're more efficient, so attorneys aren't on the clock as long, charging their clients. And also that litigants aren't sitting there for a while to, now I hear an echo, so. And the third thing is to enhance the availability of problem-solving courts. Obviously, we already have a drug court, and that's a very good court that we've got set up, and I'm going to, of course, continue it. When it comes to the drug issue, I recognize it's more than just a supply and demand economics problem. It's the drug dealers make quite a bit of money selling drugs, and it's simply a balance whether they want to make how much they can make versus how much time they spend in prison. But you got to be honest, judges' job is not to, increase time for there's standards set by the legislature, and it's the legislator's job if they want to increase punishment to criminals. The other areas, of course, are mental illness. We do have a semi-court in that already. I'd like to see that expanded. The veterans issues, and then also domestic violence is a possibility. Oh, I'm out of time.
Thank you, Mr. Woodward. I need to ask each of you to speak directly into your mic. It's a question from the audience, if you could do that for us, please. Mr. Davis, what are your top 3 priorities for your time in office if elected?
Thank you. First of all, I'd like to thank the Hancock County leadership for having this tonight. I stated last year in May when I came out and said I was running for circuit court judge that part of my goals were to increase the access to a variety of treatment programs. We don't have bad programs. I don't think we have enough, and I don't think we always have access to everyone who can be in those programs. I think we need to also do more than what we're doing with our problem-solving courts. Everybody knows about drug court. Well, one of the things I said is we need to increase the participation in drug court. Most people don't know it's got a maximum capacity of 50. For some reason, it only has 21 people in it. That's a problem. We need to make sure that we are assisting these people that have these drug problems to be able to get through drug court and improve their lives to not repeat what they've been doing wrong. We also need to, as I said in June 2017, we need to have a mental health court and a veterans treatment program. A lot of people in society deal with anxiety and depression, and some deal with it all the time. Sometimes that leads to problems. We need to have specific programs designed for them, and a veterans treatment program. I'm a member of the American Legion, and I have my son who came home from Japan, a total mess, and I understand that the veterans need to have programs when they run into trouble. I would agree with Mr. Woolridge in regards to listening to the litigants when they come into court. It's very important that we don't have a perception that the court does not listen, and we need to make sure we follow the rule of law, however it's written, not what our personal opinions are. Thank you.
Thank you. Mr. Woolridge, this question will go to you first. What alternative sentencing initiatives do you see with the rise of the opioid addiction?
Alternative sentencing. Well, obviously, what's being done is that they're not always going into jail. Many times is that, I can speak for people that get misdemeanors like marijuana and things like that. A lot of times they need to help. They need more than just, being tossed into jail. And so many times what we're doing is, we're getting them into drug treatment programs, often through the probation department, which is how the opioid court system got started. Is Amy Eichert out of the probation department started the program with, of course, with Judge Culver's assistance, and of course his blessing to have it in this court system. But I think having those opportunities where you're actually helping people and not just putting them in jail, because when you put them in jail, obviously for that time period they're not using drugs. But as soon as they get out, and we speak as attorneys knowing this, as soon as they get out, they're back to their habit. And so you've got to figure out a way that says, hey, let's get them the help they really need. And one of the best ways they're doing it is through the probation department. So alternative sentencing being, hey, we'll put them on probation for a year. They have to, go to drug classes and counseling. And they sometimes, we have clients that go to Minnesota and California to get, help with their drug issues. So that's probably going to be the forefront that we got to keep doing, is looking at these alternatives instead of just putting them in jail, because most of them are misdemeanors and not major felonies that are using drugs. And so we want to help them, of course, because if we don't, by the time they get to the end, they're going to die and have to be saved by our paramedics, so we don't want that. Thank you, sir. Thanks.
Mr. Davis, what alternative sentencing initiatives do you see with the rise of the opioid addiction?
Well, one thing that's pretty sad is, and it's one of the reasons I decided to run for judge, is I've lost 4 clients in the past few years. And whether I like it or not, I become close to my clients, and it really bothered me. And one of the things was I was thinking of what can I do to try to help people, and I do some of that in my practice. But as a court, you got to really like what Judge Culver did in regards to heroin protocol. It's thinking ahead, thinking outside the box, and trying to get something to stop the problem. But it still continues. My clients tell me that they'd rather feel numb than to live. They keep using the drugs, and they'd rather not feel anything. It's a sad case that we're dealing with. We have to continue to have the specialty courts, the problem-solving courts. We have to fully utilize drug court instead of halfway or less utilize drug court, and we have to have the other specialty courts of the mental health court, the Veterans Treatment Program, because most of my clients that have drug addictions, they also have mental health problems as well, and we need to make sure we treat them all. We're probably never going to stop everything, but I think the reality of it is if we have more policies that are directed towards rehabilitation, we're going to get more done instead of sticking all of them in jail. When it comes to dealers, obviously we have to deal with them differently, but I will never make a decision and tell you what I'm going to sentence anybody in regards to dealers until I've heard their case. Thank you.
Thank you. Mr. Sirk, what alternative sentencing initiatives do you see with the rise of the opioid addiction?
Well, we have that in place already. We have that in place through our recovery house, through our Brothers program. We're constantly putting people in those programs to encourage rehabilitation as opposed to sentencing. We also utilize alternative sentencings through the Hancock County Community Corrections Program, home detention, work release consistently. The other aspect with the drug court program that we do now already, that I followed Judge Culver's lead in, is be personally invested with each participant that is in the program. The best compliment that I've received has been from the participants saying I cared as much as Judge Culver. So those are the alternatives we're already putting in place, and we're making them effectively. As far as court efficiency, one of the main problems in that is that attorneys often arrive late, and we have to adjust that. And the court is prepared to deal with all cases that come about. As far as the number in drug court, yes, it has 50. It's the prosecutor's job to determine who comes into drug court. The judge does not determine who comes in. The judge is ensuring the integrity of the process, and he is more like the umpire, not the participant. And when they come in, the judge works with them to ensure that they succeed. And we have an 80% success rate. And the rule of law and sentencings, never does the court come in and determine a sentencing beforehand. Never would I do that. Fair on each case, and fair to each individual that's before me. And the rule of law must be followed. I do my job the best when I decide the case that is contrary to my personal feelings, and I do that consistently and every time.
Thank you. Mr. Davis, what's your viewpoint on cash bonds versus surety bonds, and why?
I was never involved in the current bond schedule. The judges, Judge Snow, Judge Marshall, and Judge Culver at the time determined the bond schedule. We used to do surety bonds back when I first started over 20 years ago, and I didn't see a whole lot of problem with it. They went to cash bonds partly, from what I've been told at least, to pay pauper attorney fees and make sure fines and costs are paid, make sure that the probation fees are paid, and I think that's probably done a lot of that. But I don't know that the stance really is surety bonds. Why couldn't we do a graduated bond schedule? You sentence somebody that comes in and their bond's $1,200, and then after a certain period of time, it's $800. You lower it down, because we should, in my opinion at least, we shouldn't have people sitting there longer because they couldn't pay bond, when the statute specifically says the concern is whether or not they're going to offend or hurt somebody back in society. We need to look and see maybe a graduated bond schedule would be more appropriate. The bond schedule that's been determined has been determined by our current judges prior to Judge Cirque being appointed. So I think it's something that when a new judge comes in, we can take a look at that again.
Thank you. Mr. Cirque, what is your viewpoint on cash bonds versus surety bonds and why?
Well, I do think that the cash bond system has served us very well, and it does more than just pay pauper attorney fees or fines and court costs, and it's more beneficial to the individual that is involved in the process. However, we do utilize surety bonds when the need arises, and we are adaptable in both situations in regard to bonds. And again, as far as the court setting a graduated bond schedule, that's not the role of the court. That would be the role of the attorney. There are certain reasons the attorneys and the clients have decisions in regard to that, such particularly in regard to their sentences or plea agreements or negotiations, but the court does immediately when there is a request to lower the bond, set that immediately within 1 week's time frame. So we are addressing those concerns effectively right now.
Thank you. Mr. Woolridge, what's your viewpoint on cash bonds versus surety bonds and why?
Well, first off, I apologize. I'm coughing so much, but I'm a little bit under the weather. Maybe people watching this probably won't realize it, but my opinion is pretty much the same of the both of them, is that it doesn't make much of a difference to me. I mean, obviously, I understand. You know, obviously, you set a cash bond. If you set the cash bond really high, then obviously, if it was a surety bond, it'd be easier for them to pay. It'd be a lesser amount. So obviously, you can adjust the cash bond, so it's not, you know, truly a big deal. So in my opinion, it doesn't make much of a difference. And of course, it is a case-by-case scenario where the prosecutor does come in and needs to make an argument, no matter which type of bond it was, what the amount should be, or if there should be no bond, and it's the defendant or the defense counsel's responsibility to argue the opposite. And as a judge, you weigh those two factors and figure out where the bond should be. And obviously, there's a couple scenarios. If they're a flight risk, or if you know they're going to harm or if you have the feeling they're going to harm someone again, then you obviously have to not set a bond. But otherwise, you know, it's one of those things where, you know, you set bonds to pay the fees. Otherwise, it may take them a while to get fees paid, and then once again, they'll end up in jail because they didn't pay their fees. So obviously, you need to get a certain amount that'll be respectable to pay the fees if possible. If not, if they're sitting in jail and they really shouldn't be, then they can come back and with their hopefully defense counsel and argue for a lesser bond amount, and listen to the prosecutor and make a decision as a judge. Thanks.
Thank you. We're going to go to some of the questions from the audience. Mr. Cirque, this question goes to you first. Do you think a judge can be impartial after getting endorsed by law enforcement officials?
Oh, of course. That endorsement goes solely to the fact that I've worked with law enforcement officials through the years, and they know my experience, and they know that I'll be a fair, impartial judge, considerate for all individuals. So I'm proud of my endorsements from law enforcement. I think that goes to the fact of my experience. I'm the only candidate that's been a prosecuting attorney. I was the chief deputy prosecuting for 4 years. I'm the only candidate that's had extensive criminal jury trial work. I've had over 35 jury trials. I've tried everything from infractions to murders. And so so law enforcement knows that, and I'm proud of that. And I don't only have endorsements from law enforcement. Well, I'm very proud to have the endorsement of State Senator Mike Kreider. I'm very proud to have the endorsement of former State Representative Nick Gulling, who was also a sheriff. I'm proud to have the endorsement and support of my campaign chairman, Bev Gard, great state senator, and continues to serve the state at this time. So I think the endorsements are proof, an indication of my ability, my dedication to the people and the citizens, and to be fair to them, and will continue to do so to all citizens. And I make it a point to decide those cases in that manner and set aside any personal biases, but I am proud to have the endorsements of law enforcement, Again, I should have said the Chief of Police of Greenfield and former Chief Clark Mercer, as well as many others. So I think it actually goes the way to be a more effective judge and a fair judge and following the rule of law and deciding the cases with compassion for each person that's before me.
Thank you. Mr. Woolridge, do you think a judge can be impartial after getting endorsed by local law enforcement officials?
I think it's possible to be impartial. It's obviously concerning for an attorney that goes before a judge. For me personally, I didn't seek out any endorsements. Obviously, when I did have to do an interview for one endorsement, I thought, okay, I'll do it because these people are voters, and so I was going to go forward and do it. But I told them point blank that if you do endorse me, that if this organization ever comes before me as a judge, I'll recuse myself. And that's just my feeling of that type of endorsement. Obviously, getting endorsements from people that would never appear in front of you in court are great endorsements because there's never going to be a conflict of interest. And nor would there ever be a question of fairness by the public. The issue would only arise if you get an endorsement from a current police chief or a current sheriff, and you feel that there may be some biasness. And the public, I think, that's probably why the question came up, is the public worries, probably when they got a mailer or seen in a newspaper that an endorsement, maybe the system truly is rigged. And that's concerning for anybody that when the public says that to you, you're worried about it. But as a defense attorney, I mean, it is concerning. If a client brought it up to me, then I would definitely ask for a different judge. And obviously, I know the current judges, obviously, recused would be more than happy. You get one time at that and say, okay, a different judge. That's fine.
Thank you. Mr. Davis, do you think a judge can be impartial after getting endorsed by law enforcement officials?
I think the real question comes down is not whether the judge can be, it's the perception that's out there from the public. Obviously, I've been asked by many people about this question, but what do I think? So I went up and looked at Canon's Rule 2.4, and on the commentary it specifically says, an independent judiciary requires that judges decide cases according to the law and the facts, without regard to whether particular laws or litigants are popular or unpopular with the public, the media, government officials, or judges' friends or family. Confidence, and this is key, confidence in the judiciary is eroded if a judicial decision-making is perceived to be subject to inappropriate outside influences. I have to agree with Mr. Woolridge. I didn't seek any endorsements from anybody. I specifically said I don't want endorsements from any person. The Professional Firefighters Union asked all three of us to come and talk to them, and they did give me their endorsement as a firefighter union. We don't see a whole lot of firefighters coming into court, firefighter unions coming into court. That's different than having police chiefs and other people that it's not whether you can do it, it's whether the public perceives on an action you did, a ruling you did, on a suppression hearing, on a sentencing or something. I never want to take the bench and have somebody be concerned about whether I'm going to be impartial. That's why I did not seek any endorsements, and I didn't talk to any of those people that have endorsed any other candidate, because I did not want an endorsement from them.
Thank you. Mr. Woolridge, what is your position on increased work release programs to better use jail space?
I have no issue with that. As a judge, you know, you set the punishments, and obviously, if you know, I have no issue with work release. I know several of my clients have said, "Hey, I wouldn't mind having work release." It's not really an option that's given by the prosecutor. Obviously, most of the time you see work release ordered by, if it was going to be ordered by a judge, it's because the prosecutor's office sets forth, "Hey, we're willing to have this person," and the defense, of course, willing to have this person do work release. And in that situation, if that's the reason, and the public safety, of course, would be a concern as a judge, and if that's not an issue, then that's something that can be done. So that's typically how work release is going to work, is that it's usually prosecutor and defenses. So for a judge, you got to realize we're kind of separate. We're not the people that are going to necessarily force things onto people. But when we make a decision of a sentencing, part of it can be work release to get them back into the community. But the most time you'll see it is usually because the prosecutors and defense worked it out, and it's a really good thing to see as a judge. But if the opportunity comes, obviously, if somebody's been in jail for a while, incarcerated for a while, you want to get them somehow back into society and be a productive member of society, and work release is one of those great options.
Thank you. Mr. Davis, what is your position on increased work release programs to better use jail space?
You know, the question is how often are you not able to get your clients into work release? On the women, I think there's 12 spots, so it's difficult, and they could sit for a long time. Clearly, we need to have more space for the women. I think many times the men need more space in there as well, because if you can go into the jail and determine a set number of people could do work release to alleviate the problem, then maybe you look at that. But as judges, our job is to sentence people according to what we feel is right. And if I think somebody needs work release, then I'll rule that they go to work release, whether it's filled up or it's not filled up. The problem and the concern is if you sentence them to work release and there's no bed space, you're gonna be sitting more and more people in jail. So when you come to this problem with jail space, we got to have more space somehow, some way. It's not my job to come up with a solution, or neither are my opponents to come up with a solution for that. However, we need to be very careful to make sure we understand what is an appropriate sentence for each particular person that comes in front of us. We have to make sure when they come in front of us, the state is going to present what they believe the appropriate sentence would be, and the defense is going to present the same thing. And if we're talking about the need for more rehabilitative problem-solving courts, then we have to have avenues in order to put those people, because we can't just have those courts and not allow some supervision of them, which means we have to have more work release space. There's ideas about how to do it, but if we're going to talk about problem-solving courts, we have to have more space, and I don't have a problem with having more space. The question is going to come about how are we going to fund it, and how exactly is that going to get done, and you can talk to your Hancock County Commissioners and Council about that.
Thank you. Mr. Sirk, what is your position on increased work release programs to better use jail space?
Well, again, I think that the work release program that we have right now is working very well. We do make the decisions on that by the individual case that is before us, and we implement it in that way, and we have to decide on that particular case. If any delay is addressed as soon as possible, and the court has to make the decision based on what's best for the community. In regard, again, to the issue of endorsements, I do need to feel I need to address this in that if you're endorsed by firefighters will come before the court. There's no exclusion of that, so any endorsement involves those issues. And additionally, my endorsements were not in regard to litigants. It was in regard to respect for the way that my experience and the way that I'll treat each individual before the court.
Thank you. Mr. Davis, what makes you a good candidate to advocate for better access to mental health resources?
Well, I think a lot of that comes down to the fact that I grew up as a kid, and I had an aunt that was manic depressant. It was my mom, Sue Davis's oldest sister. So I saw as a young child what it dealt with to see somebody stay up for 72 hours and then crash and burn and can't get anything done. She could be my aunt could be the most productive person I ever met in my life, and 3 days later she could be the worst productive person I ever met. When you deal with anxiety and depression, which I've seen tons of clients come in my office, yeah, they're nervous because they got a trouble or something, or they're thinking about a divorce. They don't know what's going to happen in their life. I've dealt with so many people dealing with anxiety and depression. I was on the Mental Health Association Board of Directors from 1999 to 2005. Pastor David Woods with Park Chapel Community Church selected me to take over for him in 1999. And when I was on that board, I learned a lot about mental health problems. I learned a lot about why they're caused, what you can do about them. And I was past president. We tried to take action to help people. It's sad. It is really, really sad. And a lot of those veterans come back and they have those issues as well. And that's why I've pushed to say we need a mental health court. And understand it's not a whole nother court. You have certain days of the week in which you deal with that, and it's not even every week. So it's not like a whole nother court process. But I think I have the background from being 6 years on the Mental Health Association. I have the experience from dealing with lots of clients and having a family that had grown up as a kid dealt with and saw the effects that mental health problems. And it's my goal to make sure it's better and that those people can be blended back into society.
Thank you. Mr. Sirk, what makes you a good candidate to advocate for better access to mental health resources?
Well, one of the main reasons is that I'm already working with that with our mental health team. I've met with our mental health providers, Kim Hall, as well as Jeff McLaren and others. I know the number of individuals that we have. We approximately now have 25 cases that have mental health components with that, and we're working that in the best way possible in conjunction with the other, with the prosecutor and other officers. Addictions that we do with the drug court, they often have a mental health component in that. In fact, that's a key part of that. And we have mental health specialists in the drug court to work particularly with that and understanding that. And additionally, with veterans, we've had veterans come through the program that have had tremendous success. The other thing about specialty courts is they do take time. There was some point about court efficiency. Circuit court is the only court that has specialty courts. We block out Fridays and half a day on Fridays, every other Friday. We also block out time for meetings every Thursday to go over the mental health team. If you add that to additional courts, you're going to have problems. Our caseload, pursuant to the Indiana Judicial Conference right now, requires 4.5 judges in Hancock County. We have 3 with the commissioner. So if you add more courts, you're going to have court efficiency problems. We're going to have to address that with the legislators and other issues to address it as our county grows, but those are all components in it, and we're successfully dealing with mental health, and we'll take steps to do so further through the drug court right now without causing any more court backlog with the great need that we have with the cases already in place.
Thank you. Mr. Woolridge, what makes you a good candidate to advocate for better access to mental health resources?
What makes me a good candidate? So the first question I'd be like, a judge doesn't make a great candidate, I think, usually, because, I mean, I majored in biology pre-medicine. My wife's a physician. I read the Journal of American Medical, I read JAMA, I read many medical journals. And that still doesn't make me the most qualified or the best to be in there to make mental health decisions at all. It's really therapists and other professionals that come in there that are the ones that make the best decisions. And that's why if you did have a mental health court or something of that nature, then you can have those professionals come in. You know, I too, I mean, obviously all 3 of us probably donate and give and want to participate and help the Mental Health Association here in Hancock County. We all have family stories. I have a niece that's bipolar. We have clients. I had a client that sat in jail, couldn't bond out, but one of his issues was, mental health. And sometimes, a lot of those mental health and even drug problems start with those misdemeanors, and you'd love to get them into circuit court to, get them some help they need into the future. Obviously, having a specialty court, this is not a job any of us are doing it for 30 or 40 hours a week. This is a job I expect that whoever wins is going to spend 50 to 60 hours a week doing. And that's because we are, like Mr. Sirk said, that we have a demand of 4.5 judges. We do have a need. We've had it on the books for about 10 years asking for another judge for our county. So it is something that I understand that no matter who wins the election, they're going to have a very tough job in front of them and expect to work very long hours and pretty much every week of the year with very little vacation. And if that's the dedication we got, then that's great, and I'm willing to do it, and I hope everybody else is too, because that's what it's going to take. Thanks.
Thank you. Mr. Cirque, this is another question from the audience. What does a judge need to do in drug court? Describe what makes our drug court successful.
Well, what we do in drug court, like I said, is we have a team that involves mental health specialists, probation, all the law enforcement officers. We meet regularly to see where they're at, where their progress is. We ensure that we do not enable them in any way. We ensure that there's consequences, and we ensure that we work on them for rehabilitation. As I said, we have an 80% success rate in that. If you graduate from drug court, you don't have another drug-related offense conviction in any way. So that's the thing, we work at that. And then we have the drug court, where I make sure that they know I'm personally invested in them. I start with a talk to them in varying degrees. I've talked about that life is, you may have setbacks, but you will come back. I try to tell stories that will relate to them in that regard. I sometimes will sit down and meet with the participants afterwards personally with other members to help them through problems in regard to that. So, and then everyone makes a comment on that, and they have the input from Amy Eichert, our director, Bev Engel, and they have a step and a process to go through working with their AA in recovery. And again, drug court has a grant. The grant requires who can participate in the program. You cannot participate if you have misdemeanors. You have to be the hardcore person with several problems and several prior convictions. And my wife and family can assure you we're already, as judges, working very long hours, oftentimes through the middle of the night. And that's part of the process, and we're glad to do it, and that's part of our commitment.
Thank you. Mr. Woolrich, what does judge need to do in drug court? Describe what makes our drug court successful.
Well, the one thing, and maybe a governor-appointed CERT can recorrect me on this, but I always thought the number was about 60%, but it's pretty high up there, 60, 80%. I know that there's many other counties also that have different programs. The other day I was reading about a program in Boone County that the sheriffs pretty much run that help people in a similar way. Obviously, when you have a client that has a felony, and I understand, oh, by the way, let me backtrack. The misdemeanor thing, I wish we could get another grant. I've written grants before for Indiana University while in my previous life. So, you know, I'd love to see if we can make that happen. In terms of the, what happens now, you know, the big thing is you get a client that, you know, usually was on death's door, was pretty much killed, brought back to life. And they're the ones that you contact, Amy Eichert, and she has to go and meet with them. And when she meets with them, she has to make a decision. I can tell you the last person we got in, she was pretty much on her third try getting into the program. They're pretty lenient, in my opinion. They'll get people in. They're trying their best to help the people as much as they can. This individual was obviously, you know, going to other states and going to other programs and showing that she had an interest in helping herself. And obviously, once that happens, then she obviously has to plead guilty to what she did, and she then gets to go through the process. And hopefully, as me and the judge have said, that she has also a great high success rate. And so that's that. And the judge, you know, that pretty much it's, you know, the approval of, you know, saying, okay, this sounds great, but it starts with the probation department and everything working out, and the person being a good candidate to make this a success. Thanks.
Thank you. Mr. Davis, what does judge need to do in drug court? Describe what makes our drug court successful.
I think the part about the drug court that is successful is the fact that, I believe it was 3 weeks ago, Mr. Cirque said it was 60% of people stayed clean for 5 years. Maybe that's increased since then. But the key is that's a lot better than anybody that goes through other sentencing. The problem I have is the fact that it's being underutilized. If you're having meetings, you're talking to the prosecutor, you're not against encouraging people to try to think how to get more people into it that could benefit from that. I've got a lot of people in drug court, but there's some bottlenecks in there. There's some difficulties to get people in drug court. I used to have a client that actually went through drug court as a misdemeanor. He didn't have any felonies. He went through as a misdemeanor, so maybe that's changed, because most of the time we are looking at felonies. And I remember at the time, Rick Culver, used to be Judge Culver, was asking why would he want to go in when he's just a misdemeanor. Well, it made sense for him to correct himself. We got to be creative and think outside the box. I had a client 9 years ago that I tried to get in drug court. It was a felony possession of marijuana. It made sense. It made sense to the probation. It made sense to the prosecutor, but because of certain rules, and it wasn't the charges, and timing is everything. You got to get them in there within a certain period of time. Sometimes there's communication breakdowns. Well, couldn't get in, so instead of just giving up, I said, why don't we create a quasi-drug court, basically drug court outside of drug court, and I got my client to meet with Kevin Minnick, one of the addiction specialists and mental health specialists with probation, and we ran drug court through Judge Snow's court, who didn't have a drug court program. And I could tell you, last year when we expunged my client's stuff off his record, he said it's the best thing that ever happened to me, that you pushed that, you got that through.
Thank you. Mr. Woolrich, how do you intend to keep children safe when they have a parent who has been convicted of a violent and/or a drug-related crime?
The first thing that comes to my mind may not be that. I think people first have to understand it's the best interest of the child. And that's, so no matter what the type of defendant may be, and I gotta be careful because of judicial rules a little bit, that you have to weigh the factors of the child's best interest, their safety and everything of this. I can tell you this, it's easier sometimes as a judicial candidate to say something that's happened in the past and not necessarily a current case or potential case that come forward. I know that it's a big responsibility for a judge when they have to make a decision on the children, because I had a situation where the judge signs the order of the child going with one of the parents, and it probably isn't the best neighborhood or the best situation for the child, but yet that's where the child ended up. And before a year could come, and we could come back and change things, the kid was murdered. These are the tough things that you deal with, not only as an attorney, but you have to deal with as a judge too, because your decisions make huge impacts on people's lives. You can go from a child being a success story to a child being a dropout. You have to, and that's why it's so important to listen to not only the litigants, but also, if you can, and there's times you can't due to the statutes, but listen to the children, and age being a factor, of course. And to figure and weigh everything. Obviously, if someone's got a criminal history, you've got to weigh it and figure out what's the best interest of the child. Thanks.
Thank you. Mr. Davis, how do you intend to keep children safe when they have a parent who has been convicted of a violent and/or drug-related crime?
I think the key is you got to look at the extent of the crime. If they're using drugs all the time, obviously there's issues in the house. I can't speak to any particular case on how I'd rule upon. You got to look to the facts of what they would be dealing with. But it's problematic if you get people that are being harmed through, their children are being harmed through violence or through drugs, that you send those children directly back to that parent that did that. That's just asking for more trouble, to be honest with you. But you have to look at it as a case-by-case basis, and you have to set parameters up of, you have to have what kind of counseling or treatment somebody has to go through in order to get their children back. You would think Child Protective Services would be involved, and they would set those requirements up for those people. The thing is the most important thing is to protect those children. And at the same time, you got to follow the law. There's laws that we have to follow that say exactly what parameters we're allowed to do. But sometimes you have to get creative. And I think if you can get, depending on the age of the child, a personal relationship with that child. I remember cases where Judge Culver appointed me to a case where he didn't know what to do about a custody case. And we had a father who really wasn't involved at all, and we had a stepfather that was really involved. and mother had died, unfortunately. And what do? Well, if you can form that relationship, if you can appoint somebody, either a child custody advocate or guardian ad litem, whichever one you want to call them, to get involved with that child, see what's going on, see how that child feels, you're able to make a better informed decision. And I think that's the most important thing you can do.
Thank you. Mr. Sirk, how do you intend to keep children safe when they have a parent who has been convicted of a violent and/or drug-related crime?
That primarily will be the responsibility of the Department of Child and Family, and the court will cooperate and work with them to ensure as best we can for the safety of the children. But as a judge, we have a very specific role, and we must follow that at all times. We're not a policymaker in regard to that. That's why in my juvenile cases, I think the cause of this is not necessarily a legal response. The cause of this is the breakdown in the family. And in my juvenile cases, whenever I have a juvenile defendant before them, I say, in my 56 years of life, the resource we've lost more than any other in the United States of America is men. We have plenty of boys, my age and older, and in between, very few men. And boys do just what you did. You acted in your own interest, for your own pleasure, with no concern for your family or your community. And men sacrifice that for the betterment of their family and their community. And that's part of what we can also do as the judge, is exhibit that and ensure that type of integrity from the bench. To address some things that were said before, I checked with drug court on regard to, I was giving a roundabout figure previously, as my colleagues pointed out. I checked with the director. We've had 94 graduates, only 18 of those reoffended, 76 had not. And I'll defer to Scott, he may be better at math than I am, but I believe that is an 80% figure. And then again, judges must follow the rules. If you want to be judge, you don't get creative, you follow the rules. There may be exceptions and you adjust those, but you follow the rule of law and you apply it. And thank you.
Thank you. Gentlemen, in respect of everybody's time, we're going to have one more question before we do our closing argument, or statements. I can't wait. I am so ready. I've been waiting for this. Mr. Davis, as a judge, we're all aware of the backlog in the courts. What can you do to keep cases moving in a timely manner?
Well, there's a few things, and as a litigant in there, I could never understand why you got afternoons and courts set at 1:30, and I would show up with my client at 1 o'clock, tell my client to appear at 1 o'clock, and hardly anybody shows up by 1:30. And so you take the bench and you can't get anything done. You can't talk to the other side. You can't talk to the prosecutor because nobody's really there. You have tons and tons of cases. It did start back of a backlog in the previous prosecutor's administration. So some of the criminal cases, that's the key. But some things you can't do. Why don't you set court 1 o'clock? Everybody's to appear. Judge Snow does a great job of making it appear. I know sometimes it's a pain. You can ask for an exception from the court to not have your client appear, but if everybody's there, you're more likely to get something done. And I've seen other courts do it. You don't come out until 1:30. It gives everybody a half an hour to try to get some things done. That way you're not sitting there as a judge on the bench, and you don't have people paying hundreds of dollars an hour to have us stand on the wall because we can't get our case called. We can't go through. So you can do some things. You could set Friday divorce day of, you set cases at 9 o'clock, you say the attorney's conference at 8:30, preliminary hearing at 9 o'clock. You force people to show up early. You get them to understand we have to be here to get things more efficient. And that way we don't have to cut people off and make them feel as though, hey, you have 20 minutes when we need an hour. You basically need to get the attorneys to say how much time do you need and try to accommodate that the best possible, because what you have is you have a lot of people out there that don't feel like they ever had their day in court because they ran out of time. Thank you.
Mr. Sirk, as a judge, what can you do to ensure or to keep cases moving in a timely manner?
Well, and I think Mr. Davis knows this because it's happened already, but I've already started setting pretrial conferences earlier on the cases that they're set. I set them at an earlier time so that we can move those cases along. The other aspect in regard to the 1:30 setting is a lot of times attorneys are part of the problem. They are not negotiating with the cases beforehand, and that's something that's up to them. So that's something that has to be done. You should contact the parties prior to that. But I have set up on the jury calendar days a pretrial prior to that to have motions done and set that up as far as any perceived backlog. In regard to the family law cases, attorneys will get the time. They have to request the time. Court time is valuable. There's many times the courts has time set. Attorneys continue matters or move them, and that court time then is wasted. But we set the time, and if they ask for an hour, they get an hour. If they ask for a half day, they get a half day. If they do not ask for a time, and it's on the family law docket, they have a half hour. The court cannot tell what time it is. They have to set that. And we are addressing that and moving those cases along.
Mr. Woolridge, as a judge, what can you do to keep cases moving in a timely manner?
Well, first off, I think it sounds like we're starting to diss Hancock County's courts. It's not that bad. If you go to other courts like Marion County, it's much worse. So it's not too bad in terms of moving cases along. Yeah, occasionally, I know I have a case in his court, so I won't go into it too much. But, and sometimes you have to, as a lawyer, go up to the judge and see if they'll help you out and work with you when a case isn't moving very long because of the litigants or, as he says, sometimes also the attorneys. With him talking about how sometimes attorneys aren't prepared, I agree. I think one of the big things, and something that Marion County actually does pretty good, is that, and although they force everybody to do it, is that you have to have more mediations, especially in family law. We need to look at mediation as an opportunity, especially when you're a judge and you know the lawyers very well and you know that those lawyers don't do well, don't play nice negotiating. And so you have to have that option on the table to steer them towards mediation on the ones that you know need to do that. And it's something that we like to see be done more in this county. In terms of I mentioned as one of my goals that, improve the efficiency of the court. That's more towards the issue that litigants have, clients have, and attorneys sometimes have, is what we term in the industry cattle call, which is when everybody has to show up at like 8:30 a.m. And you never know if there's going to be 5 cases that morning or 0 cases or 12 cases. And if it's a huge number, then there's obviously an issue. And that's where I think, to me, is the biggest thing that we can probably improve on in terms of so people don't sit there for hours on end waiting to have their case heard. And I know usually what we're able to do in this court system is that a lot of times we'll use the commissioner to help out a judge that has that scenario one day. Thanks.
Thank you.
As I stated earlier, this is going to be our closing arguments. We'll call it a closing statement. Does that make it better? Mr. Cirque, you will have 2 minutes to address the crowd.
Okay. Well, thank you. Again, I am your circuit court judge. I was appointed by Governor Holcomb to be the circuit court judge. All of us applied for that position, and I was selected. And I hope the voters of Hancock County vote for me as your circuit court judge as well. And I'm asking for your vote today. I'm the only candidate before you that's been a prosecutor. I was the chief deputy prosecutor for 4 years of Hancock County. I'm the only candidate that has extensive jury experience as a litigant, trying over 35 cases as a prosecutor and as a criminal defense attorney and as a civil litigant in Hancock County, in the Hancock County Circuit Court. I'm the only candidate before you that has been a judge and presided over jury trials, criminal and civil. I have also served as your court commissioner prior to being appointed by Governor Holcomb for 8 years. I was appointed to that position by Judge Culver and Judge Marshall and Judge Snow. I work with them and understand the collegiality and need to cooperate in all the courts and will continue that which we've been blessed in Hancock County. Judge Culver not only appointed me court commissioner, he also endorsed me in this election for judge. I have the experience. I've been there. I know what is needed to be done. I will continue to cooperate and work with the leaders of Hancock County and the citizens and be compassionate to the families and concerned for the well-being, follow the rule of law, and follow the cases. You do your job as a judge when you decide it in a way that you wouldn't personally like, but the rule of law and the facts demand that. Thank you very much.
Mr. Woolridge, you have 2 minutes to address the crowd.
I want to thank everybody for coming today, and thank you for having this put on. I also want to thank my opponents for being quite cordial and nice today. And they were friends before, and they'll be friends after for me. Right now in Marion County, they're going through a process of determining, setting up 3 new judges. And the thing when you're setting up new judges that have never been elected before, the thing that they're going to be looking at is judicial character. That is the #1 thing they're going to look at. When I think of judicial character, I think of Judge Culver for myself. This is because when Judge Culver, first got onto the bench, he was never a judge before. He actually, my understanding, had less years of practice than I did, and all 3 of us actually. And Judge Culver was, for the most part, a great judge. And I would say, beyond anything, it was his judicial character. For me personally, I'm going to be a judge that's open-minded. I believe that we need to have independence, fairness, impartiality, integrity. People need to understand that I'm going to be someone that's open-minded and fair. I have a judicial mindset to always follow the law, and it's not what my opinion is. That doesn't matter. We need to, as judges, follow the rule of law, and we don't legislate from the bench. You need to have a strong work ethic, because there is a large demand for our work and our time, and we're going to work long hours to do the best we can. I'm committed and flexible, and I appreciate your vote between now and May 8th. Thank you very much.
Thank you. Mr. Davis, you have 2 minutes to address the crowd.
Yes, first of all, I'd like to thank Hancock County leadership, and I'd really like to thank the public for coming out today. Besides going door to door and trying to get information to you through Facebook, et cetera, it's difficult to get to people. So thank you for coming. I don't always agree with what Senator Mike Crider says or does, but one thing I certainly do agree with is we're on the verge of losing a generation due to the opioid crisis. Hancock County is my home. I was born here, but more importantly, I've been invested in this community for more than 20 years. I was on the Mental Health Association board like I talked about. I was on the Child Protective team. I handled cases for 6 years in front of Judge Culver on specialty cases that were difficult. He wouldn't have appointed me if I couldn't get the job done. It's important to realize that this isn't just a job for me. This is my home. I want to better my community. I have helped thousands of people better their lives. And I think I can do a better job by going into court and helping people through programs that are set up through court and through letting people know they will be heard in court. The status quo, simply put, is just no longer good enough. We can't keep going on the same path. If everything was good enough, then everything would be peachy keen around Hancock County, and it's not. We keep on losing people. We have people with perception problems with the court. It's time for a change. I mentioned all the specialty courts. That's because I think that's part of the solution. I believe we need a fresh new vision for the Hancock County Judiciary. I believe I'm the right man and the right choice, and I would appreciate your vote between now and May 8th. Thank you.
Thank you. That will conclude our debate for Circuit Court Judge. I would like to thank each one of our citizens for coming out and trying to become a more informed voter. Gentlemen, I would like to thank each of you for your time and your candor. We appreciate your information. Thank you.
Thank you.